Harry Littman, the United States Supreme Court strikes again. What they've showed thus far is while they're willing to stand up to Donald Trump on some of the far reaching authoritarian stuff and push back now on that, when it comes to some of his other cruel policies, they, on procedural grounds, are allowing Trump's cruel stuff to take place. Now, they're not siding with him on the merits. And in my view, they too cute by half themselves and cut themselves in half with these procedurals. Oh, all we're saying is we want to issue a stay and preserve the status quo. But when you look at what they're actually doing with a lot of these Trump dangerous decisions, their staying is kind of a merits-based decision that seems to be using the shadow docket to fundamentally alter what the real status quo is. So let's talk about one example, but we could talk about others where they're doing this and what this means for some of the other litigation that may be coming their way. So on Tuesday, the Supreme Court, the headline is Supreme Court will allow the Trump administration's transgender military ban to take effect. There were three noted dissents. The liberal justices dissented and basically said Trump's transgender ban should not be taking place. And really what the majority was saying in this, who agreed to this, allow the transgender ban to take effect, is we're just issuing a stay. We're not necessarily even saying we agree with the transgender ban, but the executive, because there's all these presumptions for the executive, made an order. The order became the status quo. And the status quo was transgender ban, to which point people in the transgender community and others challenged it. And a district court judge said, no, I'm issuing a stay or an injunction to block that from happening. I want to preserve the status quo, essentially, which is that transgender people who are serving in the military can still serve in the military and not be banned. So what the Trump administration did when they went up to the Supreme Court is ask the Supreme Court, can you stay, lots of stays here, but I want to bring this logically. Can you stay what the district court ruled when they said transgender people can now be in the military? Because what the Trump people say the status quo is the order being remove transgender people from the military. So the Supreme Court granted a stay of the district court's order, but effectively that means Trump's transgender ban, which fundamentally alters the rights in the military, goes into effect. And then in my view, the harm and the damage is done, and you can't unring that bell. Perhaps a little bit of a complicated discussion there, Harry, but the Supreme Court, the headline is transgender ban in effect, but the Supreme Court is using the stay of the district court's order as their, we're not saying that. We're not actually bad people. We're just saying let's preserve the status quo as it was before the district court made that ruling.
So exactly right. If you think about it in a lawyerly way, it seems very sort of picayune and complicated and labyrinthine. Here's precisely what they did. A district court judge in Washington said, I think there's a lot to what the plaintiffs, the transgender people who want to serve, are saying. So I'm going to put a hold on this new order while I decide, because nothing's been decided yet, including even now. And then what the Supreme Court said by 5 or 6 justices is that district court shouldn't have imposed a stay. And we're now very familiar with this. Stays involve special showings of you're probably going to win and the balance of equities are with you. And there's a lot of reasons. it's a complicated kind of legal rationale. And because they go on this emergency shadow docket, we don't even know what the majority of the Supreme Court are saying. Are they saying it's on the merits? Are they saying it's on the balance of equities? But let's say it's on the merits, because I think you're right that the most natural interpretation is at least a majority of them are saying, we think this order can well stand, and we're going to let it go into effect while the district court determines, and it comes back up to us. Of a case from a couple terms ago in which a majority of the court, in an opinion by Justice Gorsuch, basically said, you can't, to the extent you can't discriminate on the basis of sex, that means sexual orientation. It ought to mean transgender status. So are they sort of staking, drawing a line that says when this comes up to us on the merits, we're going to carve out from the normal kind of protections we give to people based on issues of sexuality and sexual orientation and just, one's basic body? Are we going to say transgender? No, that doesn't count. Everything else does. Man, that'd be pretty harsh. Or are they just saying, for now, until it's really decided, you haven't shown enough for whatever reason? There are 4 different, criteria for having this stay that the district court imposed. For now, you haven't shown it. We're not going to know it for a little while. So it's either a pretty picky procedural thing where it's not a big deal in a way, except as you say, even if it's not a big deal, tomorrow, transgender people, there are over 10,000 in the Army, are basically out. And even if they win a year from 2, they've gone on with their lives. The practical on the ground consequences are really severe. But then there's the possible legal doctrinal consequences. Will the Supreme Court actually make transgender status a kind of world apart that doesn't get any protection? That is the bigger kind of legal issue that hovers in their very, specific procedural ruling.
We've seen, though, this, I think, gaming the stay issue also with when Donald Trump's been firing the people from when we've seen some of the right-wing conservative-leaning circuit courts of appeals do this as well. When Trump would remove somebody from like a specific board without cause, and the person would be arguing the status quo is return me to the board, and Donald Trump would say no, we're arguing, or the courts would eventually say no, the status quo is you were removed, now you have to fight for yourself to get back on through the litigation, but you're presumed the stay that should be issued is we're staying the district court. When the district court said you could return to the board, let me just read the language to people so they could hear me say it, because I think it's important that, that we read the words. It's short. The application for stay presented to Justice Kagan and by her referred to the court is granted. The March 27, 2025 preliminary injunction entered in the United States District Court for the Western District of Washington, case number blah, 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 is stayed pending the disposition of the appeal in the United States Court of Appeals for the Ninth Circuit and disposition of a petition for a writ of certiorari if such a writ is timely sought. Should certiorari be denied, this stay shall terminate automatically. In the event certiorari is granted, the stay shall terminate upon the sending down of the judgment of this court. Justice Sotomayor, Justice Kagan, and Justice Jackson would have denied this application. And for what it's worth, Justice Ben, had I been on the bench, would have denied this application as well, because
Justice Harry as well. Yeah.
Because what I would have wanted, look, I believe transgender people should serve in the military. It's an ultimate sacrifice you're making. We shouldn't discriminate. But let me move beyond just my own personal views about human beings. My own view of it would just be the status quo is that transgender people were in the military. That they were fighting for our country and dying for our country and sacrificing for our country. So to me, if I was a judge, I would just say, look, persuade me that they shouldn't be a part. Persuade me to really fundamentally create an injury to these people and push them out of something where they want to belong. Convince me of that. So I would say, let's go through these proceedings. We could hold a trial, present your evidence to me. And I would view the status quo as them staying in the military, setting aside my own personal views. But, this is the issue with this Supreme Court where and lots of right leaning doctrinal stuff, which it is sometimes used the way the way kids would argue sometimes that heads I win, tails you lose.
Right.
And you kind of come up with a framework to justify it. I'm a strict contextualist. Go back to I'm an originalist. But the text says this. Well, actually, there we have to go back to the founding fathers' true interpretation. And it's like, all right, you're just gaslighting me. You believe something, and you've come up with frameworks to win the argument, no matter what. And that's what I see a lot of this as.
All right. And I do want to say you're really right in terms of the practical impact on the ground. You're a transgender person, and tomorrow you've got to leave the Army. So let's say in 2 years that on the one hand, as you're saying, they're saying, it's still the Ninth Circuit's going to decide. Then the Supreme Court might take cert and decide, and the stay is in effect. While that happened, by the stay, I mean the non-stay, the actual status quo based on the order and not how it was before. But let's say it all works out and they recognize, as it just seems they should in any kind of principled way, how can you discriminate against transgenders but not homosexuals and not, it really does seem of a piece and equally sort of mean-spirited and irrational. But if they eventually decide it, and they decide in the right way, still, you're a transgender person. It's been 2 years, 3 years. The law grinds slowly, and life happens quickly. And by then, you've moved on to whatever it is. You've probably lost your opportunity of serving your country, which they, as you say, in the ultimate, sacrifice, decided they want to do. So these little procedural things have real impact on the ground. And I think in addition to the legal standards, we think number 1, 2, 3, and 4 are all met here. The progressives are saying they're also basically animated by a feeling that you've decided this without deciding it, you 5 or 6 members of the majority. That kind of stinks. And, it's a historic, as this happened before with homosexuals, right? You are now doing the same historic, grievous misstep of telling people that, in effect, at least this generation, these few years of possible transgender recruits may not serve in the Army. That's a pretty serious kind of social discrimination. And it really is heads I lose, tails you win with these kinds of orders, because it's all about what happens on the ground. Last point is what happens on the ground. That's what these emergency orders are for. The Trump administration has already, in its month and its 103 days, whatever, sought emergency relief more than the last 8 years of administrations have done. So you could have said, what's the big emergency here? Let them serve while we decide. But they've gone to the Supreme Court and said it's a terrible emergency. We're being terribly prejudiced. And in the meantime, they win and get to keep transgender people from serving, and in a way that, as I say, for these particular service members is probably life conclusive.
There you have it, everybody. Just subscribe to the Talking Feds YouTube, Talking Feds Substack, and Talking Feds podcast. You just search Talking Feds on all your devices, Substack on YouTube, podcasts, and subscribe. It's where I get my news from. Thanks, Harry.
Thank you, Ben. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.